Today, I'd like to talk about what's going on with state regulation of AI. States have enacted a raft of laws to regulate AI in so called high risk fields, which includes healthcare. A number of these have recently become effective or will become effective soon. At the same time, the regulatory landscape is a mess. In late 2025, the Trump administration issued an executive order aimed at preempting state laws that might inhibit AI innovation. On top of that, we're seeing active litigation challenging whether these state laws are even constitutional. For founders and operators in healthcare tech, it's a confusing landscape. So, what are the actual steps you should consider for compliance? Let's look at three examples. The Colorado law is the one everyone is watching. At a high level, it requires companies to prevent algorithmic discrimination. For high risk systems, that means mandatory annual impact assessments and consumer disclosures. The Virginia High Risk AI Act focuses on systems making so-called consequential decisions about consumers, a definition that clearly covers healthcare-related choices. Finally, a California law effective as of 2025 requires healthcare providers to be transparent and disclose when AI is being used to generate communications to patients. If you're a smaller organization, you might be looking for an exemption. In Colorado, for example, the formal impact assessment requirement only kicks in if you have 50 or more employees. But this doesn't exempt you entirely. Even smaller companies must still exercise reasonable care to prevent discrimination. If your AI tool substantially influences a negative outcome, like denying a patient's treatment or insurance coverage, you are still legally required to provide notice. So what should your next steps be in this uncertain environment? First, take an inventory. Catalog every high-risk AI system you use that could fall under these laws and conduct your own risk impact assessment. Second, look at the NIST AI Risk Management Framework. If you have the resources, lean into the NIST framework. Here's why it's a good defense. Over time, implementing this framework can provide some preemptive protection, since it is likely to be used as a standard in multiple states. What it can do is give you a rebuttable presumption that you have complied with risk mitigation measures and shift the burden to state regulators to show otherwise. This is the case, for example, in Colorado and Virginia. The environment is shifting frequently, so track effective dates closely. It's tempting to stay in reactive mode while the courts sort out the federal-state conflict, but taking some proactive steps now will better position your business and can significantly reduce your long-term risk. And that concludes our Free Flow update. Thank you for joining us today. For more information, please visit our website at orensteinlegal.com and navigate to the podcast page. Remember to subscribe or follow Free Flow on Spotify, Apple Podcasts, and YouTube so you never miss an episode or update. This podcast is for informational purposes only, is not legal advice, and does not create an attorney-client relationship. Thank you for listening.